you're on, big guy.
Just got 10 copies of this, you want to pass them around. This is the normal update that we pass out every month. Just update on construction. While work is still progressing, mainly tying in small pieces of conduit and that sort of thing for electrical.
He made it. Sorry, Doug. Oh, pretty boy, you're not looking good today.
I'm fighting the battle.
Don't even touch it. Breathe on it.
Anyway, work is progressing, but really until the bond money rolls in, there's no of the larger work can be done in regards to scheduling equipment of some of the final pieces to pull everything together. And schedule, our contract is still, we're talking 6 months from payment, which we're getting pretty close to that September deadline that we have listed here, but we have made provision for temporary pumps once the money gets here. Financial update, you can see a whole laundry list of things that have to be done before we obtain our money. The last little bit of these items is we need to get the agreement signed by the respective boards and get the bond resolution passed by this board. That information has been sent out to all the attorneys, and I know that we are in the, and I don't know whether Tom's going to update on that or not, but I know that we are in the process of trying to get that wrapped up. I believe the City of Elizabeth is going to have another work session to discuss the issue, but hopefully we'll get things wrapped up pretty quickly and then actually sell the bonds so we can make some payments, get everybody back to work. Second page, and this is something that you do not have to take action on this evening. It could be done now or at a later date, and these are numbers that have already been factored into all the numbers that have been given to everybody. There's actually 4 items with the Beck Mountain water tank. One was some site changes under the tank access road. We actually found a cavern under there that we had to pump full of flowable fill. The cost on that was $5,998,000.17. You can see the labor was almost nothing. It was all relative material. We needed some additional pipe to make sure that our tank and Siam's tank would function together and give us some options and filling really both of the tanks. That was $6,564.38, and also some additional fencing which has already been installed. That actually takes the fence to the top of the slope instead of the bottom of the slope, which is a little different than the way the existing fence run, but is where the fence really needs to be to protect the area that we have up there. That is $8,224. Then the last item is a credit of $2,000, and that's changing the overflow pipe from ducted to PVC down in the tank. Total amount of money for the change order, averaged together, $18,786.55, and it is already included in all the cost reductions that we've done to this point.
So it's already there, we don't have to do it
Yeah.
for another 18 months.
That's correct, and it's still less than our original cost of bid time. That, we had a cost-saving exercise. We took out about $45,000. This essentially put about $18,000 back, but the cost is there, and the cost is covered. Whatever the board's pleasure is, whether they want to go ahead and enact this tonight or save it for next month's meeting.
What are you asking for then? You're asking us to make a decision or what?
Really just making you all aware of it.
Just information only right now?
All the calls. It's in a situation where you could approve it if you need to. Contractor's not going to put this on his cost estimate until the board approves it, but we have at least about 40 days before that's done. So.
We had approved.
I was going to say, if it's just a matter of approving it now, it's not come due yet.
That's fine.
I would say just approve it, that's my thought on it, back from the board. Have a different thought, or what you're thinking on? If we approve it now, it's not due now until whatever we get to it, right?
If it's approved, it'll be a done deal. We won't have to come back to the board for any additional action. It would be the easiest course of action.
My thought is to approve this at the time. Is there any thought otherwise? Anybody got a different take on it? We need a motion and a second on this to do this?
You do. Need a
Is
motion.
there a motion to do what we're just now talking about?
I'll make the motion. Go ahead and approve.
Is there a second?
I'll second.
Moved and seconded to approve these changes to come due when it's time to do it, right? That's what it says. Okay.
Make a formal motion to make changes when the appropriate time.
Well, what is the motion we're making?
Yeah, I
You
mean,
work
we
this
need a
for us
formal-
today.
it's kind of a formal motion.
I think the board needs to make a motion to approve these change order items as listed. Simple as that.
Okay.
That's what we're moving and second. Everybody's still good with the move and the second on this? All right, let's simple. Are we spending money now? We got to call the roll on this?
Yeah.
Call the roll, Brian, please.
Mayor Alexander.
Aye.
Jeff Chambers. Harden Gentry.
Aye.
Mayor Humphries.
Aye.
Chairman Mills.
Yes. Approved unanimously. Take care of that. Anything else, Doug?
Will you have to answer any questions?
Questions for Doug? Anybody? Okay, we've got the old curmudgeon here. So
Go ahead
I
and breathe
think-
on you.
Don't touch me, don't breathe on me. He's been sick.
Interviewing witnesses on one mountain today, so on my big lawsuit I got to drive.
I'm going to discuss this.
It's good to see you, but I was concerned about you when you had some health problems. You're looking good. Thank you. Basically, we always try to communicate with the South's attorney, Bill Bubner, anytime they indicate they want us to do that, and I did that, and I sent Bill Bubner a copy of the proposed agreement, change amendment to the agreement to him, and Ray, I had not heard back from him, but I did send that over to him, fax it over to him, so that's something you may want to follow up with him on.
Yeah, he's in South Carolina.
Okay. Now, this lawsuit with the Thomas Construction, obviously anybody that we owed money to certainly had the right to sue us. And apparently we did not keep Mr. Thomas informed as to what we were doing. He wasn't aware of the fact we were moving forward and we were expected to be able to sell these bonds any day. And so they filed a lawsuit which did get our attention. And I immediately talked to Bill Bubner and Rick Beerfield, who was his attorney. And Thomas, as you know, along with Frizzell, we had the three best contractors we could ever have on this project, and they've been very, very good to us. And Gerald Thomas agreed immediately to go ahead and take a voluntary dismissal, and he did. His attorney did put some conditions on that. The first of which was for me to accept service on the lawsuit, so that there wouldn't be any question about any time statute running, which I'll do that myself. Agree to reimburse Thomas for the cost of the lawsuit, the attorney's fees associated with that, which should not be much because it's simply a title thing and nothing's been done on it. Agree not to assert this dismissal of the defense on any other action that might be brought in the future. In other words, if they decide they have to proceed against us, not to be able to say this dismissal precludes them from doing that. And then to assure them, make a commitment that the bond proceeds are sufficient to pay Thomas Construction and all other creditors in full, and that their invoices will be paid before within 21 days of receipt of the proceeds of the sale of bonds. And that's the only one I didn't have any control over, and I talked to Doug about that, and Doug said the only concern he had was whether or not they're talking about interest that they were claiming in the lawsuit, and he changed his proposals to eliminate that, so that wouldn't be part of the thing. And then the fifth one is provide reports to Thomas Construction regarding the status of the issuance of the sale of the bonds on a periodic basis. So basically, in briefest terms, we just have to pay the cost, court cost associated with this lawsuit. And it'll be dismissed, it's what's called a non-suit. And I just have to make sure that's done. So I would ask that a motion be made to accept the proposals that's set out in this document here. And I would that we can, and that we can go ahead and proceed forward with it.
Any questions for Tom? Anybody doesn't understand exactly what Thomas is saying?
I do have a question. What about the other contractors? Have we brought them up to speed as well so that we won't see a repeat?
He's doing
I've
that.
personally talked to all the other contractors and also informed them in regards to Thomas's lawsuit and the fact that it was being brought conditionally on these items. And I think all of our contractors want everything to go as smooth as possible in regards to obtaining our bond money and consequently getting everybody back. And I think the biggest issue was Thomas was lack of them knowing what was going on.
I'd be the first to point out that Brian has done what we hoped it was being done all along, and that is he's gone out to South Utility and met with those folks out there and had a meeting and answered their questions. He's ready to go to Siam. He's talked with Mark, any questions Mark has had. I think we can try to get him answers pretty quick. So we're doing, Mr. Thomas just kind of got left out of the loop, and I think this was kind of a wake-up call, and Mr. Thomas will do exactly what we say we'll do in this letter right here. And it should make Mr. Thomas happy. We're doing much better now that Brian has taken the time to.
You have a motion and a second.
Need a motion and a second to approve these conditions to make it feasible for Thomas to dismiss the lawsuit.
I'll make that motion.
I'll second.
Moved and seconded. All in favor say aye.
Aye.
Any opposed? It's unanimous. That is a big piece of good news.
Can I give you a brief update on the legal aspects of the bond issue, just to let you know?
Excellent.
Basically, you're dealing with a bunch of attorneys, some of whom are bond attorneys. All they do is work on bond issues. And one of their functions was to look at all the documents and interpret all the documents to make sure that it was legal to issue bonds and stuff like that. And since we were dealing with a private act in this case, we weren't dealing with a standard statute that everybody deals with in most cases. And they went through the private act and raised issues concerning things that had to be cleared up, or revisions that need to be made, and things like that would allow this. That's the reason you have the amendments to these contracts. And what you're trying to do is you're trying to convince bondholders that want to invest their money in your utility that this is a safe, solid, good investment. And obviously, the clearer it is and the less confused it is, the better off you are in selling that. And so basically what we've done, we've worked, not we, but they and all the attorneys for the city. Eric Herron had issues that he wanted raised. And we've all worked out together, and we have what we all feel is a reasonable proposal that we made to both South and to Siam, and we made to the city of Elizabeth. And we feel like that we hope that the city of Elizabeth will approve their agreement. Eric Herron has had a lot of input into it, and I feel like it's a solid agreement, and it should get everything moving forward and get done in a prompt manner. But basically, the lawyers have finished their work. We just simply need to get the approval of the city of Elizabeth, and we're ready to go with this.
Has that been forwarded over to schedule a workshop or anything?
I don't know, but Eric has it. You can
Okay,
check
I'll
him
call
on that. But see, that's in Eric's,
Right.
and he's as good as there is.
Yeah, no doubt.
That's news we wanted. I mean, that's, I'm not gonna give you better news than that until we sell the bonds.
Yeah.
Could we ask Cyan in particular, maybe South, to get a copy of that?
So the city lives in, yeah, yeah, we sure can. Yeah, Brian, do you have that? You know, I can get it over to you.
No, I guess it's dead.
That was actually one of the provisions that's done in the agreements to make sure that all of the different folks that are signing their particular agreement also has the same information that's in the other agreements.
Yeah.
So,
Just kind of
which
build
is-
on what Tom said, this is nothing that's changing what we're paying for water, really. I mean, this is only, there was a couple things in there about depreciation. You know, the depreciation of pipes. I know we had a question on the city. We were in our contract depreciating pipes over 75 years. Well, we checked with the state, and the lady at the state said, well, we need to take that down to 50. Even though the useful life may be 75 or 100 years, they've never seen them depreciated over 50. So that actually increased the cost of water, not the rate, but the cost of water, because in government you have to physically fund your depreciation according to GASB standards. So you have to set that money aside, so that increases the cost, which is why we want to have a workshop and, you know, bring that before council, because it is going to cost money. Second thing, they needed to change the contract, I think, from 20 to 30 years. We had a 20-year contract. The bond issues for 30, so they wanted to take that from 20 to 30 so that we have revenues to cover, you know, the whole length of the commitment. So those are the things that we're trying to get back to the city, you know, to get those little things that these attorneys pick up on. That a
Well,
lot
you
of,
get the better rates, the more, you know, the more coverage you have, the better rates you're going to,
right.
the more sale it is to the bondholder.
So that's what
And
we're.
one other factor that was a little bit, that was one of the harder ones to work through is simply because the city of Elizabeth was so generous or so helpful to us when we really needed help and gave us the $5 million contribution, which they've already paid, and they're already paying interest on that money. And we knew when that happened is that that was the end of their capital contribution. And so basically, we had to show that essentially what they were paying is the equivalent, that they paid was the equivalent of what our members would be paying over the 30 years of the bond as far as the debt service is concerned. Because there was a provision in the private act that said everybody has to be treated the same. So that's what that situation is. And so they felt like that was, even though it wasn't the same, it was equivalent to the same as far as that money. When you project how much money to be paid and the cost of money and inflation and everything, that'd be the same.
So when these other utilities get to 5 million, are they gonna be at that point also then?
Well, basically, when they get at the 5 million, together they're all projected to pay about that much money on present value basis at the end of the 30 years. See, what I'm saying is you're making, they don't own, City of Elizabeth doesn't own it.
Yeah,
They don't
that's
have
the
an
difference, I think,
they
between
don't have an
Elizabeth
ownership
and the
interest.
members, is that at the end of 30 years, we have nothing. At the end of 30 years, the members still own the plant.
Yeah.
You know, so Elizabeth is gonna have to renew, and we have no
The
asset.
problem is you only have 2 members here.
Pardon?
There's only 2 members that's paying into this surcharge thing. That's where the.
Well, that's
freak
great,
is.
because you all were the smart ones. You all got in at the beginning when you should have, and you know, I dare say over the next 30 years, we're gonna have a lot more members than we do now. Because that surface water plant is going to be the crown jewel for Carter County and Elizabeth, and there's no doubt in my mind. It's just painful right now for you guys and for you guys, but it was very painful for Elizabeth to come up with $5 million to give to something that we're not going to own. Would you buy a $5 million piece of property and not own it? Probably not. It's tough. So we have a lot of skin in the game to make this thing work and make it fair and equitable for everybody.
Yeah, but we're having to explain to our customers each month.
Oh, and we do too. We've got to explain to ours
The $5
because,
million was a grant, wasn't it?
was what?
It was a grant.
No, that's
Oh,
borrowed
that was
money from the
borrowed
bank.
money from them.
That's, we went and borrowed money in a bond issue to fund that $5 million. We're paying interest on that every month. And we forwarded that money in advance. And then we're going to be buying water. So they're not giving us water. We're still entitled to have to buy 300,000 gallons per day, every day for 30 years.
Same rate.
At the same rate, right?
It's my understanding our workshop, Mr. Unger came out and did a presentation. It was my understanding that y'all be getting back $3.7 million out of that bond.
What,
Will you explain it to us?
yeah, they're,
Talking about depreciation credit.
right,
Yeah.
as the bulk rate is established, both in your contract and in Elizabethton's contract, you basically take your cost of operation and maintenance plus the cost of depreciation, which is the same for everybody, including the city of Elizabethton, divided by the amount of gallons. That's how you come up with your bulk rate structure. What is different is that the city of Elizabethton, because they put the $5 million up front, is they get a credit back on that depreciation, because the theory is that they're not paying depreciation on money that they've already spent. Okay, they've already put the $5 million down, so they get a credit back. Basically, the form that's been established is, and this was in the original agreement that was signed, you have the amount of money that Elizabethton has paid, which is $5 million, divided by the total project cost times that depreciation value, and it works out that Elizabethton will be getting back about 27% of the depreciated value, which calculates out to about $114,000 per year. And that money is only to be paid back to the city of Elizabethton if the funds are available. If the funds in any particular year are not available in the contract, it rolls into the next year. The plan as pointed out by all the attorneys is that they didn't want that payment back to the city of Elizabethton to put Watauga in dire straits from a financial standpoint, so that money would transfer to an upcoming year. But yes, there is a credit of amount of money for depreciation that does go from the single-time payment from the authority back to the city of Elizabeth. Basically credit for $5 million.
And two, because we don't own the assets, so we don't fund depreciation on assets we don't own. So it's not that they're giving money back, it's that we're not gonna fund depreciation on assets that we don't get at the end. So it's really not even money back as far as for the rate or whatever. But as soon as I get that from Eric, we'll schedule a workshop in the next week and get that taken care of.
You got a motion second on this,
Motion second on what?
on this thing here.
We already did that.
We already did that.
Okay, good.
Don't confuse me, Tom.
I got red, I got, oh, man.